Welcome everybody to today's webinar. I'm so glad to see we've had such an interest in this event and a huge number with almost 250 people attending today. So it's great to have you all with us. My name is Eleanor Flynn and I'm the Director of the Centre for Disability Law and Policy at the National University of Ireland, Galway. So I'm just going to explain how today's event will run before we start the proceedings formally. As you'll notice, we have international sign language interpretation throughout today's event. We are also recording this event so that it can be watched back later by those who could not attend today. And we also have captions, real-time captions for the event, which you can access by clicking on the Captions tab, or also by clicking on the link that has been posted in the chat if you want to view the captions separately. If you want to ask a question to one of our panelists in today's session, a Q&A box has been provided, so please post your question in there. If that option is not accessible for you, please press the raise hand button if you wish to answer your question with your mic on, and then one of our team will enable your mic function when we reach the Q&A portion of the webinar. We will be hearing from all of the panelists one after another in the first hour of this session, and then we will take a 10-minute break around 3 o'clock and come back to the Q&A session. So please use the Q&A function. If anyone needs their video enabled, if you want to sign your question instead of just your mic, then please send a message to the panelists in the chat box and we will enable your video for you so that you can ask your question in that way. Okay, I think that is most of the housekeeping. I just want to also mention that we are live tweeting this event, and if you want to join us and tweet along with us, then you can follow at NUIGCDLP, and we're using the hashtag #NotJustBritney with capital N, capital J, and capital B. Okay, so without further ado, I want to introduce you to our esteemed panelists for today's session. I will be speaking first to lay out some of the human rights context for our discussion today. And after me, we'll be hearing then next from Dr. Anna Arstein-Kerslake, who is an associate professor at the University of Melbourne and will be taking up a post at the Irish Centre for Human Rights here in NUI Galway in September. And Anna has a long history of research and advocacy on disability rights in general, and especially on legal capacity and supported decision-making. Kristin Booth-Glen is a retired Surrogates Court Judge in New York and director of the Supported Decision-Making New York project. She is also an emeritus professor and dean of the City University of New York. Alberto Vasquez is a senior advisor at the Center for Inclusive Policy. He's a Peruvian lawyer and disability rights advocate and president of Sociedad y Discapacidad SODIS-Peru. Previously, he also worked as a research coordinator at the Office of the UN Special Rapporteur on the Rights of Persons with Disabilities during Catalina de Vandas's mandate. And we also have Michael Njenga from the Users and Survivors of Psychiatry Kenya. Michael is the head of programs in that organization and also a board member of the Pan-African Network of Persons with Psychosocial Disabilities and a member of the World Network of Users and Survivors of Psychiatry, who's been very involved in not just law reform, but practical efforts to support users and survivors of psychiatry in Kenya and more broadly in Africa, and also in global law reform efforts too. So without further ado, I'm going to give you some of the background context for why we organized today's webinar and set the scene in terms of the human rights context that I hope will inform the rest of the discussions we have throughout the session. So I'd like to start by saying that obviously our starting point for today is that what is happening to Britney Spears now should not be happening. But in developing today, I've been having a lot of conversations with others who are, like me, quite frustrated about how so many of the reactions to the powerful testimony that Britney Spears has given in her conservatorship case, how many of the discourse in the public domain and media representations have been lacking a disability rights analysis of her experience. And I and those involved today, we firmly believe that if we're to free not just Britney Spears, but everyone else living who's living under a similarly oppressive system, then we need that disability rights analysis. So that's why we organized today's event. Throughout today's session, you may hear us refer to disabled people or people with disabilities. And I want to be clear that when we use this umbrella term, we include people who are labeled with a disability or diagnosis, even if that's not how the person would self-identify, because human rights law protects their rights no matter how they identify. And also, I want to foreground our discussion by saying that disabled people have been calling out the problems in adult guardianship for a long time. And I want to acknowledge all of those disabled people, especially on social media, who have been giving such important analysis to what's happening in this case and its wider implications. So people like Imani Barbaran, C. Mia Roll, Kathy Flaherty, so many of the people who have been acknowledging that what is happening here is a systemic issue and one that deserves systemic reform. So let me explain a little of the human rights context for this discussion. Many of you know that 2 years before Britney Spears was placed under conservatorship, representatives from countries all around the world, and indeed from the global disability rights movement, were finalizing the negotiations on the UN Convention on the Rights of Persons with Disabilities in New York. And I want to read an extract to you from a newsletter that was developed by the International Disability Caucus, which was a coalition of disabled people's organizations and other global organizations working on disability rights, who came together to negotiate and to ensure that the convention would reflect the concerns of the disability community. So the newsletter that they published during the negotiations in the final stages, in the final year of the negotiations in January 2006, said as follows: imagine if someone else was making decisions for you. They could decide to take you away, lock you up, not listen to you, give you medication, block you from doing your work, and living your life with your body and mind the way they are. Would you want this to happen to you? Wouldn't you have the feeling that you have lost your dignity and want it back? Wouldn't you feel your integrity has been violated? Wouldn't you want to have support in making decisions without being taken over and to ask for help without being seen any the less for it? So these words are, I think, very resonant now when we have heard Britney Spears' testimony, and also when we know of the experiences of so many other people who live under substitute decision making. And I think it's really important for us to return to that negotiation and understand what emerged from it and what the text of the UN Convention actually says about this issue and how it applies in this and in other situations. I know many of you today attending this might be quite familiar with the convention and with Article 12 in particular, but because we have a fairly mixed audience, I'd still like to remind us of some of the key provisions of that article to frame our discussion for today. So in Article 12, some of the most important statements I'm going to underline here. It says that states parties shall recognise that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. Now, this is really important to remember, that legal capacity is something that must be granted and recognised in disabled people on an equal basis with non-disabled people. And that, of course, includes people who've been labelled with a disability or a diagnosis. Legal capacity, of course, means the ability to make decisions that must be recognised and respected by the law. So making contracts, wills, getting married, deciding what medical treatment to consent to, and so on. And this is precisely what has been denied to Britney Spears and to others living under similar substitute decision-making systems. I'll come back to that term in a moment. The other aspect of Article 12 that I want to highlight again is its statement with regard to supported decision-making, or in the words of the article, states shall take appropriate measures to provide access by persons with disabilities to the support they may require in exercising their legal capacity. So again, here we're seeing a statement that people must have access to support. And as we have seen from what the UN Committee has explained since this document was created, this does not mean that because someone asks for support or uses support, it should never result in the removal or denial of their legal capacity. So after the convention that I'm speaking about now entered into force in 2008, the CRPD Committee, that's the Committee on the Rights of Persons with Disabilities, was established to monitor the progress of states under the Convention, and it began having dialogues with states, reviewing their reports and providing concluding observations. And some version of the following sentence appeared in almost every concluding observation the committee made. So to almost every state that appeared before it, it said, the state must review the laws allowing for guardianship and trusteeship and take action to develop laws and policies to replace regimes of substitute decision-making by supported decision-making, which respects the person's rights, will, and preferences. I think it's important to highlight the committee said replace here. So they're not suggesting that we can add supported decision-making as an option and keep our systems of adult guardianship. They're actually asking for a complete replacement of guardianship altogether. And this reflects the discussions that happened throughout the negotiation of the convention, where advocates maintained that it was possible, even in hard cases, even where people had very complex communication, to support people to make decisions, rather than to take away their right to make those decisions for themselves. So the final thing I want to say is to clarify what we mean when we talk about substitute decision-making and supported decision-making. And these terms were clarified by the UN Committee in its first general comment, which, as I think some of you know, myself and Anna worked on in supporting the working group that developed that general comment. The committee defined substitute decision-making as a situation where legal capacity is removed from the individual, even if this happens just for one single decision and not in respect of all areas of their life. The committee has also clarified that a substitute decision maker is someone who can be appointed by someone other than the person themselves, and it can be done against the person's will. And finally, the committee said that substitute decision making includes any decision made by a substitute decision maker if they are bound by what they think is in the best interest of the person, as opposed to the person's own wishes, or in the language of the convention, in the person's own will and preferences. So it's important to remember that even if only 2 of those 3 criteria are present, it constitutes substitute decision-making. Supported decision-making, by contrast, is less clearly defined, perhaps, in the general comment, and there are good reasons for this, because this practice is still evolving all around the world. But the committee did lay out some key principles of support that we need to remember. So it must be available to all people, regardless of their level of support needs, or whether they already have people in their lives who can help them to make decisions. The safeguards must be based on respecting the person's own wishes or will and preferences. The person's communication or lack of financial resources must not be a barrier to accessing support. It must be possible for the supporters chosen by the person to be legally recognised. And the use of support in one area can never be used to justify a limitation of the person's other fundamental rights. And of course, very importantly, the person must be able to refuse, change, or end the support at any time. So what does this mean for Britney and everyone else under substitute decision-making right now? I would argue that we should be challenging the continued existence of adult guardianship laws with every possible means. That includes bringing legal challenges, arguing they violate constitutional rights and legislative rights to equality, bringing political pressure to bear on these issues, and not just settling for minor procedural reforms, but continuing to argue for radical legal and social change. There are human rights obligations that can be persuasive in court decision-making in guardianship cases, even when the country, as in the case of the US, has not ratified the UN Convention. But we'll hear more about that from our panelists later. And I also want to say that we do have support in this struggle to change these laws and practices. We have colleagues around the world who have made great progress, not just in law reform, but in practical supported decision-making projects. And we will hear more about that later as well. But before we move forward to make that change, it's important to understand exactly what we're dealing with in these systems and the principles upon which they're based. So with that, I'm going to hand over to Anna to tell us more about the Californian conservatorship system.
Hi, Eleanor. Thank you so much. And hello to everyone here today. I'm really happy to be here, and it's really wonderful to see the high number of participants. So thank you so much, everyone, for joining today, because it is such an important issue, as Eleanor has highlighted. Um, as she mentioned, I'm an associate professor at Melbourne Law School, and I will also be taking on a new role at the Irish Centre for Human Rights at the National University of Ireland in Galway in September. So I'll be continuing both roles. So I'll be sharing my time between Melbourne and Galway. One of my primary interests is the right to legal capacity. And I've been working in this space now for, I don't know, around 10 or 15 years. And I think that the maybe three pieces of work that I've done that are maybe what I think the most important or the most relevant is my first book in 2017 called Restoring Voice to People, in which I really lay out a lot of the legal interpretation, the details of the legal interpretation that Eleanor just went over regarding what the right to legal capacity means, particularly in the context of cognitive disability. And I won't go into too much more depth there, because I think Eleanor did a really good job of laying out the important things that we need to talk about today in that area. The second book that I published just came out this year, and that's on legal capacity and gender. So in that book, I look at how and when legal capacity is denied on the basis of gender, and how women and gender minorities are experiencing legal capacity denials differently. Now, unfortunately, today we don't have time to get into that in relation to Britney Spears, but I think there is some really important stuff that I just wanted to flag for you about gender in the context of Britney Spears. And maybe particularly in the context of Britney Spears experiencing profound objectification of her as a woman. So I think there's lots of interesting things there, and of course there's also the dynamic that the conservator is her father. Again, I can't get too much more into that today. I think we could do a whole nother webinar on the gender dynamics of the issue. But I think what I want to focus on today actually is looking at the general comment, which is the other piece of work that Eleanor and I did that I think is a particularly relevant one today, and talking about the conservatorship law in California, and how it does not, basically completely does not, fit in with what is permissible under Article 12 of the Convention on the Rights of Persons with Disabilities. So without dwelling too much more, let's get straight into the conservatorship law. So conservatorship is, for those of us that aren't familiar with that term, it's basically the same as guardianship or interdiction, trusteeship. More or less, all of these terms refer to the same idea of a substituted decision-making regime and legislation that permits substituted decision-making. In California, it's called conservatorship. And I wanted to mention as well that this is both an issue that is important to me professionally and personally. I'm from California, if maybe you can tell from my accent. And my sister, who I grew up with in California, we grew up in California, has a developmental disability, Prader-Willi syndrome, which comes with intellectual disability. And she also has an acquired mental health disability, schizophrenia, and severe anxiety. So we, my family, and my sister and myself have unfortunately been faced with this conservatorship law over and over again. And the context in which we've been faced with this law is that many services that my sister, her name's Sarah, has tried to access either require or strongly prefer the individuals to be under conservatorship. This is really difficult for my sister, myself, and my family because none of us want a conservatorship for many reasons, even under the context of my sister needing significant support making decisions frequently, in fact, on a daily basis, because part of her disability is related to food choice. She has hormones that make her feel hungry all the time. And people with her disability have eaten themselves to death. Their stomachs have ruptured and they have died. So it really is a daily presence in her life, the need for support for making decisions, this is also a reason why conservatorship law has come up over and over again when trying to access services. We have successfully avoided it, but it has meant that we need to be aware of it, and it feels like an ever-present restriction looming over my sister's life and our lives, something that we're always fighting. Now, the reason that it is that this is damaging and that this is a difficult thing to deal with is because of the profoundly restrictive nature of California conservatorship law. It not only meets all of those elements of substituted decision making that Eleanor described, so it's imposed against the individual's will, it denies legal capacity, and it takes a best interest paradigm. But it also allows the conservator significant powers to invade the conservatee's personal, professional, educational, social life. So what I think one of the key things I wanted to go over with you today are the 7 powers of a limited conservatorship in California. And I also want to note that a plenary conservatorship is also possible, which is one thing that actually has been widely sort of critiqued around the world, both in the context of the Convention on the Rights of Persons with Disabilities and outside that context. So just a sort of an acknowledgement that plenary guardianship is bad practice, plenary conservatorship is bad practice, and what plenary conservatorship or guardianship is complete denial of legal capacity, with the individual no longer enjoying any personhood, legal personhood, or legal agency. So that's possible under conservatorship in California. And a limited conservatorship where specific powers over the individual are given to the conservator is also possible. And I want to go over those 7 powers that are 7 of the powers that are possible, and they're specifically laid out as well. In fact, when applying for a conservator over someone in California, there's a form you can fill out that allows you to tick boxes for these to say that you desire to have these powers over the individual. And I'm mentioning that because I feel like that is profoundly disrespectful of the individual. The fact that you can tick box away these areas of someone's life. So the powers are number 1, to decide where the conservatee lives. Number 2, to have access to all financial, health, and other records related to the individual. 3, to make choices regarding the individual's education and employment, including terminating employment and ending, beginning or ending an employment contract. 4, restrict the individual's contracting powers, so not allow the individual to contract without the permission of the conservator. 5, consent to medical treatment on the individual's behalf. 6, control the social and sexual contacts of the individual. And 7, have decision-making power related to marriage of the individual. I hope that those surprise you as much as they did me when I first read the as much as I was when I first read the legislation. I think that it is a violation of Article 12 of the Convention for the reasons we discussed, and I think it's also simply not a way we want to organize society. I don't think we want a society where you can go to a court and that court can determine that one individual can legally control the social and sexual contacts of another individual. That appears to me a profound violation of an individual's privacy, dignity, rights, the list could go on. So I think I'm gonna wrap up here. And I hope that this has highlighted for you the very problematic nature of conservatorship in California from a human rights perspective. And I think also simply from the perspective of how we want to treat each other and how we want our governments and our courts to be able to treat us as individuals and the power that they have over us, which is of course related to human rights. But I will pass over, I believe, to Chris now, who will talk a little bit more about how human rights in general is a difficult context in the United States. Thank you so much, everyone. Wonderful to be here. Thanks.
Thank you, Anna. And it's a very short statement about how the human rights context is working in the US, because the answer is it's not. The US is one of, I think, 2 or 3 countries, Sudan, I don't know, North Korea, that has not ratified the CRPD. So we have no appeal to the human rights lens at all. And basically, it's just not in the conversation. It is sneaking in some ways through supported decision-making, and I'll say a little more about that in a minute. But what I thought would be important to do would be to give you sort of the context of what's going on in the US, particularly because although there's an enormous outcry and a huge amount of publicity and everyone's talking about it, and sort of everyone in the disability and aging communities are writing letters to the editor and saying this is so wonderful because it's shining a light on guardianship and now everybody's going to know. I'm not nearly as sanguine about this as many people are, partly because I've been involved in the earlier reform movement around guardianship in the US, and also because I think it is that the conversation now is rooted in a very deep level of prejudice against people with disabilities, both cognitive and developmental and intellectual. So first, just with regard to the kind of background of guardianship or conservatorship, the terms are used interchangeably in different states. The U.S. is a federal system, and so guardianship law, and I'm going to say guardianship laws are state laws. So there are 50 of them, plus the District of Columbia, plus I suppose the territories as well, and they're all quite different. Although in some ways they are all the same in that they do take away the legal capacity of the people who are put under guardianship. There may be guardianship of the person, of the property, or both. There may be more than one statute in a state. For example, in New York, we have a general statute, guardianship statute, which is mostly used for older people who, quote unquote, had capacity and have lost it. And then a very special statute which has very few, if any, protections for people with intellectual and developmental disabilities who are deemed to have never had capacity. Our guardianship laws are used primarily for older persons with dementia, with cognitive decline, and for people with intellectual and developmental disabilities. very little use for people with psychosocial disabilities, largely because most guardianship laws do not permit the guardian to commit the ward to a psychiatric institution involuntarily. And that's really mostly what people who want to be guardians for people with psychosocial disabilities want to do. So it just is not used widely at all. In the late 80s and early 90s, there was a huge reform movement in the US to reform guardianship laws, which were quite antiquated. It was mostly around procedural protections. You were required to show that the person was in some danger or had a real inability to care for themselves or their property, and an inability to understand and appreciate that danger or the inability to care. And one of the big changes, besides all the procedural improvements, and there were certainly those, was what purported to be a move from a medical model to a functional model. And so this was no longer about a diagnosis, except, for example, in the statute for people with IDD in my state, it is no longer about diagnosis, but really about a functional analysis and examination of what the person actually could do and couldn't do. And I think that becomes quite relevant with regard to Britney's cry, "I do not want an evaluation. This is I don't need a psychiatrist or a doctor to tell me what I can do or not." Those statutes from that reform also had a very clear preference for limited guardianship. They have a very heavy burden of proof of showing what the person can't do and only allowing a guardian powers over those areas. And yet, even though that is clearly the preference and there's a clearly and strong burden of proof and a lot of procedural hoops to go through, almost all the guardianships in the US are plenary. Partly because people think, well, if the person is disabled now, they're only going to get more disabled, and why should the petitioner have to come back to court? So let's just take care of it now. It's in everybody's interest to do so. Whereas in fact, it's obviously a profound violation of human rights. So I want to say a little bit about restoration or termination, restoration of rights or termination of guardianship as well, since that's obviously the big issue right now for Britney. Although I really want to make this point, which is not widely noticed, which is that in the many years of her conservatorship, Britney has never asked that it be terminated. And in fact, even in the last set of legal activities, it's really only been about her objecting to who had power over her life, not that someone else did. So she didn't want her father, but she acquiesced to the court-appointed personal guardian, to the financial institution, which is the co-conservator for her money and so forth. So it's very interesting to understand why that's happening. She has a lawyer. The lawyer is court-appointed, but in the U.S., lawyers have an obligation to zealously represent the interests and spoken wishes of their clients. Her lawyer is not a guardian ad litem or someone who's working for the court. So, I just raise this because I think things are not perhaps as clear as they might be. In terms of restoration and termination, there are very few cases, very few reported cases. The statutes are all over the place. Some don't even mention it. Some provide a procedure. Some just say it can be done. So courts are kind of, making it up as they go. One of the real issues, though, in terms of termination and restoration is the question of burden of proof. That is it the responsibility of the person who wants to continue the guardianship to show that it's still needed, which I and most lawyers would argue is what's required under the Constitution, or as it is being claimed in California and under the California statute, is it Britney's obligation to show that she is quote unquote no longer incapacitated, and to do that through basically a medical evaluation. So I think this really highlights the critical fact of the continuation of a medical model which has been completely abandoned in the human rights discourse, but which is so incredibly prevalent and strong in U.S. guardianship law. So even though guardianship statutes are state statutes, there is one federal, or there are some federal issues, but there is one major federal issue, which is our Constitution. So in addition to the protections and limitations in the statutes and the case law, there's also, at least supposed to be, an overriding constitutional imperative. That is that when the loss of personal liberty or control of property is the result of the state's parens patriae power, that is, its protection of the person as opposed to the protection of other people from the person, which would be criminal law, then the least restrictive means available must be employed. Otherwise, saying that guardianship is the last resort. From the 80s on, there have been fairly limited alternatives considered, primarily about money, powers of attorneys, trusts, supported SNTs for people with developmental disabilities, representative payee status for receiving Social Security benefits, and in the personal needs area, basically healthcare proxies. But there's a catch there, primarily for people with developmental disabilities. And that is that all of these documents require the person to have had legal capacity, read as mental capacity, at the time that they entered into the agreement. So for older people who have, quote unquote, lost capacity through a stroke or through progressive cognitive decline or dementia, that may not be an issue. But for people with developmental disabilities, they are deemed never to have had capacity. So those documents simply cannot be accepted for them. And I think that goes to Anna's point also about how service providers really push people into guardianship because they want to have someone who they know unquestionably has legal authority. And because there's always this question for people with developmental disabilities, get a guardian, then we know that we're okay. So at least in theory, the burden to show that guardianship is the least restrictive alternative should be on the petitioner, but in practice, and I was a judge in the regular guardianship area for 10 years, and then more recently as surrogate in the other guardianship area, that question is never asked. Judges just don't say, what else did you try? Did it work? Didn't it work? Isn't there something else we could do here? It's just not in the conversation. So here's where supported decision-making enters, and sort of legal capacity enters silently, invisibly, but there in some good ways, I think. As people, and I would say mostly legal academics, and the occasional judge like myself who was and again is a legal academic, began learning and talking about supported decision-making really based on the work that was being done around the world, it was fairly quickly picked up and it was touted as the less restrictive alternative that those of us who were trying to limit or abolish guardianship had always been waiting for, especially with regard to people with developmental disabilities, precisely because they were deemed never to have had legal capacity. And in 2012, in a hearing to terminate guardianship for a woman where I had actually imposed the guardianship, woman with intellectual disability, who had by then developed an informal network of people who were supporting her in making decisions, I wrote the first decision that actually named supported decision-making as a less restrictive alternative, and also, and it's like probably one of only 3 still in the US, specifically found that it was required by Article 12 of the CRPD, and that it was a means to the legal right, to the human right of legal capacity under Article 12. So beginning in 2014 in the US, even in the absence of any empirical evidence, there were no pilot projects, there was nothing going on here, people started embracing supported decision-making. The Federal Agency for Aging and Disability, by the American Bar Association, by the National Council on Disability, everybody was talking about supported decision-making as an alternative to, as a less restrictive alternative to guardianship. And in 2016, a large national organization called the Uniform Law Commissioners that writes model statutes that states are welcome to adopt, and many do, decided to reform their guardianship law, their uniform guardianship law, and did so over a 2-year period that I was involved in. And that new model law, the Uniform Guardianship, Conservatorship, and Other Protective Proceedings Act, specifically names supported decision-making as a less restrictive alternative, and more to the point requires that the court find that it has been at least considered, obviously we would have liked tried, but considered before guardianship can be imposed. And I think even more significantly from a practical standpoint, it requires the petitioner to plead that supported decision-making has been tried or at least considered, and why does not work or why it failed. And I think that's important because a lot of people have no idea that there is an alternative, and this requires lawyers in the business to at least inform their clients that there is, and perhaps give them that opportunity. So a number of states have already revised their guardianship law to kind of match up with the Uniform Guardianship, Conservatorship, and Other Protective Proceedings Act. And there are also now decisions in at least 6 state courts where judges have specifically held, again, that supported decision-making is a less restrictive alternative to guardianship. But it's far from over. And again, this notion of the shining of the light is I think, being overly hyped. First, because any of this is still dependent on overcoming the paternalism and especially the biases against people with developmental disabilities that run so deeply in our society. And especially with regard to older persons, and in the case of Britney, a younger person, but for the same reason, there's a huge set of entrenched financial interests. People make a lot of money off of guardianship for older people. And as with everybody who makes money off of something, they have more voice in what the law says than a lot of other people, including those who are disadvantaged by it. So this is one place where the Britney story does shine a light on something that the public, I think, basically had no idea about otherwise. But secondly, even if supported decision-making significantly reduces substitute decision-making, which is to say a lot of people don't get put under guardianship because now they have a less restrictive alternative, or as with the project that I'm directing, people get out of guardianship because now they have a system of persons who support them so that they no longer need guardianship. I mean, I say that not assuming that they ever did need it, but in terms of the law. But even if we got rid of guardianship altogether, we're still in a system that has plenty of other laws that restrict or deprive legal capacity, that are just kind of invisible to everyone. And there are many gatekeepers, from the county clerk who issues the marriage license, who even in the absence of guardianship can just say, wait a minute, you know, you look like a retarded person to me. I don't think you should get married. I'm not giving you a license, and on and on and on. So I want to make clear that the deprivation goes well beyond guardianship, even though guardianship has primarily been our target. And at best, frankly, there are just going to be some more reforms that occur within a system that is filled with bias, both explicit and implicit, against people with disabilities, that does not recognize the human right of legal capacity. And our research shows that particularly the implicit bias against disabilities is the strongest bias there is. It's stronger than race, it's stronger than gender, it's stronger than sexual preference. It's really extraordinary. So my big caveat is this, that while the whole conversation about Britney may shine a light on guardianship, it is also very powerfully reinforcing those biases through what is referred to in the literature as confirmation bias, through the constant cry, and if you follow the social media in this, you just hear it over and over and over again, that guardianship was not meant for and certainly should not be used on someone like Britney, a hot, young, talented moneymaker who, except for the fact that she's richer, more gorgeous, and more talented than almost anyone alive, is just like us. That it's really and appropriately for older people, for people with dementia, and for people with disabilities. So I would just caution us all in our conversation about this to be really careful, not only to use the human rights lens because it's the right lens, but because it's the only way at getting at this separating out the worthy person who should not be under guardianship from all those who clearly should. Thank you.
Thank you very much, Chris. And now we will move on to hear from Michael Njenga, who's going to talk about the global barriers that disabled people, including users and survivors of psychiatry, face in systems of substitute decision-making. So over to you, Michael.
Thank you very much, Eleanor. I think it's a pleasure to be able to contribute to this particular conversation. I will start by saying that, of course, the traditional legal response to what is perceived to be a decision-making deficit was to allow other people to make decisions in place of persons with disabilities. And I think the whole conversation around legal capacity goes beyond decision-making to the core of what it means to be human. That our freedom to make choices is greatly diminished when our legal capacity is taken away, yet our life choices are fundamentally part of who we are. I think looking at the impact of substituted decision-making regimes on persons with disabilities generally, it's important to sort of point out that, first of all, it teaches persons with disabilities to be dependent and make them to be helpless, which in essence devalues their humanity. And I think it's very important also to underscore that all human rights are meaningless if you do not have the legal capacity. And lastly, it is about how other people perceive persons with disabilities, that substituted decision-making regimes have a huge impact on how other people, for example, service providers, public officials, and members of our entire community view persons with disabilities. If persons with disabilities are seen to be incapable of making any decisions about their own lives, then negative stereotypes about disability are reinforced, yet these stereotypes are a significant barrier to the inclusion and participation of persons with disabilities in the society. I think the right to legal capacity in itself is just not a right in itself. It is also a precondition for the enjoyment of many other rights in a person's life. If legal capacity is not, for example, fully recognized on an equal basis with others for persons with disabilities, it will have, for example, it will have a direct access. It will have a direct impact on the ability to access effective legal remedies and the ability, of course, to enjoy other human rights on an equal basis with others, which is at the core to fully and meaningfully participating in the society on an equal basis with others. This, for example, in Britney's case has been demonstrated as she's unable to effectively access the justice system, to challenge the conservatorship orders which have denied her the equal protection of the law and the equal access to participation in the legal process and its utilization thereof. I mean, for me, it was profoundly shocking, to say the least, that shortly after Britney Spears made her statement, the court recessed, and upon its return, the transmission was stopped. The orders against Britney have made it difficult for her to even choose her own attorney. And this demonstrates the enormous barriers persons with disabilities face globally when they are deprived of their legal capacity and put under substituted decision-making regimes. It is also worth noting that most cases of guardianship, for example, in Kenya, the person whose capacity is being determined is not even given an opportunity to appear before the court. I think for me, at the bare minimum, the court would deem it important to see the person whose capacity is being determined, considering the magnitude and impact of any decisions arrived upon, will have in the person's life. The other thing to point out, of course, is that substituted decision-making regimes, of course, are built on pre-CRPD vague tests, such as the best interest concept, and the concepts such as unable to manage one's own affairs, which results in curtailing of the rights of persons with disabilities to make their own decisions and to have those decisions respected by others, and a host of numerous human rights violations. I think once legal capacity is restricted and persons with disabilities are, for example, put under substituted decision-making regimes, such as guardianship, a legal representative, for example, will be appointed to make decisions on their behalf. And the presumption is always that, of course, these decisions are being made in the best interest of that particular, person. I think it's also good to note that in many countries where we might not have formal guardianship, but a lot of people are, of course, put under what we call informal guardianship, where decisions are being made, for example, by their family members or by their communities or by their societies. I think in the context of women with disabilities, it is important to, of course, note that the regime of substituted decision-making operates within a framework of gender stereotypes and gender-based violence, putting them at particular risk of being placed under substituted decision-making regimes. Furthermore, in most countries, women with disabilities are prevented from making autonomous decisions with regard to their reproductive and sexual health and rights, resulting in highly discriminatory and harmful practices. And this was, highlighted in the special report on sexual and reproductive health and rights of girls and young women with disabilities. I think lastly, in conclusion, as a society, we need to objectively question the overarching principle in substituted decision-making regimes. That is, of course, the proverbial statement that we are acting in the best interest of a person. For me, the fundamental question in my mind is always, we are acting in the best interest of whom? And why is it that at the core of most guardianship cases, there's a huge pecuniary interest involved? It's either about money, property, and other forms of assets. I have grown up in a context where I have never seen any guardianship case being instituted if there are no huge financial interests involved, and even where people are informally denied the right to make their own decisions, the substantive area of interest is always in relation to the ownership and inheritance of land or other properties within the family. It is clear in Britney Spears' case that no one is acting in her best interest, and what is taking preeminence here is probably the financial interest of other interested parties. It is quite contradictory that where she's deemed incapable of managing her own affairs, she is still being presumed to have the capacity to continue working and performing on tour in different places. I mean, during her court appearance, she did not look like someone who was unable to manage her day-to-day affairs, just to say the least. Lastly, we must be very conscious of the relationship between substituted decision-making regimes and mental health laws. As long as they allow for involuntary detention, forced treatment, and forced medications of persons with disabilities, these laws are contrary to the rights of persons with disabilities, including their right to legal capacity. I think the system have taken away more than 10 years of Britney's life, and the Free Britney movement is also a global call to abolish and prohibit all regimes of substituted decision-making. And these regimes, of course, include plenary and partial guardianship, judicial interdiction, curatorship, conservatorship, and mental health laws that permits for involuntary treatment and commitment. All forms of substituted decision-making are prohibited under the CRPD, including those based on the assessment of mental capacity skills, and must be replaced with supported decision-making arrangements of varying types and intensity, including both informal and formal support arrangement that must be provided within a human rights framework. Thank you very much.
Thank you, Michael. Okay, In the interest of giving us a small break before we hear from Alberto, so we have time to digest all of the amazing insights we're getting from our panelists, I will just ask us to take a 10-minute comfort break now, and we will return at 3:07 my time. And so I look forward to continuing the discussion with Alberto when we return, and also to hearing from you, the attendees. Please remember to post your questions in the Q&A box for our panelists. Thank you and see you soon. Okay, so over to you, Alberto.
Well, first, thank you for this space, and good afternoon and good morning to everyone. And I think it has been discussed today how guardianship, curatorship, and other forms of substitute decision-making are prevalent still around the world. And its day-to-day reality actually feels hopeless. However, in recent years, a group of Latin American countries have accomplished what seemed impossible: ending guardianship for persons with disabilities and implementing different forms of support decision-making. And let me stress the fact that I'm not talking about revising guardianship laws or moving towards a functional approach in guardianship. This is about abolishing for good guardianship based on disability. And the first country was Costa Rica, which in 2016 adopted the law for the promotion of personal autonomy. And this law recognized legal capacity for all people with disabilities, abolished the different forms of guardianship they had in the legal system, including interdiction, insanity, curatorship, and introduced this new legal institution of the guarantor for the equality before the law of persons with disabilities. And the role of this guarantor is to ensure the full enjoyment of legal capacity of persons with disabilities, and to support individuals while making legal decisions. No? And the guarantor is bound by the will and the preference of the individual with disabilities they are supporting, and it must be appointed by a court. This law actually has many gaps, and it's true also some contradictions with the Convention on the Rights of Persons with Disabilities, for example, in relation to the right to informed consent, to treatment. But it's an important law because it opens a way, I think, for other countries in the region to go further in their impetus for reform. And in 2018, Peru, my own country, adopted a major reform of its legislation to recognize the legal capacity of persons with disabilities. And this reform is considered a milestone because it's probably the closest to the CRPD committee standards on legal capacity. And it has been celebrated from the United Nations to the Inter-American human rights system. And there are some differences with the reform in Costa Rica. The first one is this reform was driven by a broad movement of organizations of persons with disabilities and human rights organizations, including organizations of people with intellectual and psychosocial disabilities who were actually at the front lines of the debates. And second, because this reform includes changes in many pieces of legislation, including the Civil Code, the Civil Procedural Code, and the Notary Law. And for those of you who are not familiar with these legal instruments, a civil code is a codification of private law relating to property, marriage, family, contracts, obligations, and other aspects of life. And changing the civil code in a country with a civil law tradition is actually very challenging, particularly when you're addressing the core of the civil code, who has or not the capacity to act. But this is at the same time, I think, the strength of this reform in Peru. It gives visibility to the right to legal capacity and makes the reform more sustainable. And this reform also recognizes different forms of support decision-making, not just one measure as in Costa Rica, but many measures. And this includes advanced decisions, private support agreements, and court-appointed supporters. And so people have different options to choose. And I think significantly, the law also establishes that even when the person cannot manifest its will by any means, even after being provided of reasonable accommodation and support, a support framework should still be applied instead of guardianship. And in such cases, supporters must follow the best interpretation of the will and preference of the individual. Of course, the Peruvian reform has also some problems. Safeguards are rather weak, and there is no clear link, at least in the law, with the mental health legislation. Although the new mental health regulations have been adopted to fill that gap, and in a positive way, I think. And also some groups were left out and could be still placed under guardianship. Not people with disabilities, but for example, drug users, people with criminal convictions, people in coma, and those that we call in Peru and other civil law countries, prodigals and bad administration, basically people that spend a significant amount of what is considered a restricted part of your patrimony because you have forced heirs. And of course, there is a concern that these grounds may be misused to restrict the legal capacity of persons with disabilities. And 1 year later, actually in 2019, Colombia also adopted a major reform related to the legal capacity of persons with disabilities. And like the Peruvian process, the reform in Colombia was also driven by a coalition of organizations of persons with disabilities and human rights advocates. And this reform also abolishes guardianship and introduces different forms of support decision-making. And this includes, like in Peru, advanced decisions, private support agreements, and support appointed by courts. And something interesting is that the Colombian legislation expressly authorizes, for example, the inclusion of so-called Ulysses clauses, which are self-binding provisions, for example, authorizing third parties to ignore the most recent expression of their will. The reform in Colombia also includes a procedure for the assessment, for example, of support needs of individuals. And although this reform expressly abolished provisions providing for the voluntary hospitalization and treatment of people with psychosocial disabilities, there seems to be still a debate whether these practices are fully prohibited or informed consent is not required in case of emergencies, following previous Constitutional Court jurisprudence. But a common feature in these three legal reforms is the acknowledgement of the Convention on the Rights of Persons with Disabilities and the CRPD committee standards as a guiding framework, and even as an interpretation framework, as it is stated in some of them. So for me, the question is this a path that other countries can follow? For sure. And we have seen recently Spain taking steps towards a fully CRPD compliant framework, actually based in some of the examples in the Latin American region. Would Britney will be safer in Costa Rica, Peru, or Colombia? I think so. She cannot be put under a conservatorship, even if there is still a scope for a highly debatable application of mental health legislation. It will be a rather small window of possibility. To put an example, mental health regulations in Peru today permit internment in a psychiatric facility without an informed consent only when there is a medical emergency, the person cannot manifest their will by any means, there is no supporter appointed, and only for 72 hours. And that doesn't even allow forced medication. Of course, the biggest problem in Latin America is the implementation gap. Judges and public officers may misinterpret the law, and stigma and discrimination will still happen, and there is little accountability. And another example, for example, recently in SODIS and Redesfera, two organizations of which I am a member, presented a legal action just last week against a private psychiatric clinic, asking for the release of a person who had been involuntarily admitted. And this person was released before the court intervention, but it was a new pleasant feeling to have finally the law backing our claims rather than having to fight the law. And although it might have sounded impossible probably a few years ago, but Britney could well qualify for asylum in one of these countries. Because I think there is no worse prosecution than the one that results in your civil death, not to mention ill treatment, as has been mentioned. Thank you.
Thank you so much to all our incredible panelists for sharing those remarkable insights about the different barriers that exist and the possibilities for dismantling them. So I want to turn now to some of the questions that we have received and to see how our panelists may wish to answer these questions. So the first question is about how we answered the question of what does supported decision-making look like in practice, and particularly if we can, as panelists, reflect on some concrete examples, especially for people with high support needs. So we've already addressed, Alberto, I think you have, the second part of the question, which is about the laws regarding ending guardianship. But I think it would be useful for us to reflect on the other practices that may or may not be included within law reform. So I might ask Michael first, and Chris also, if you could speak a little bit to that issue, especially from the projects that you've worked in around how we can support people in practice, especially people with high support needs. And I can add some thoughts to that as well when you've both spoken. I'd
like Michael to go first.
Okay,
All right. Thank you very much. So we documented over a period of years the relationship between peer support and the exercise of legal capacity. And we worked through one of our support group in Nairobi in Kenya. And what we found out from extensively documenting and trying to establish, is there any relationship between peer support and supported decision making, was that the relationship between peer support and supported decision making, or rather the exercise of legal capacity, is multifaceted in Kenya. So just to explain a little bit, is that we found that on one level, there's a direct link between peer support and the making of certain decisions that have legal consequences. This was very, very specific, especially in regard to mental health treatment decisions. And just to give examples, that, for example, during peer support group meetings, members would get information from each other, for example, about certain procedures like electroconvulsive therapies. And the members would also get information about human rights, including what others can or cannot do to you legally. And once the peer support group members got this information, they were able to tell, for example, their doctors or their family members explicitly, I do not want to have ECT. So that was the first level. At the second level, we found that the link between peer support and the making of decisions that have legal consequences is indirect. In these cases, peer support fosters agency and autonomy, and in turn boosts the exercise of legal capacity. In these instances, after attending peer support group members over a period of time, the peer support group members start to reclaim their voice and to become more assertive. In part, this may be because they see other people who share similar experiences making their own decisions and being in control of their lives. In essence, then, the peer support group members goes out into the world with a different outlook as an empowered agent other than an object of treatment. At the third level, we found is what we call autonomous decision-making. This is where peers assert that they do not always need to use peer support to make a decision. At this level, some peers have already made a decision and only present the decision to the peer support group to receive feedback on decisions already made. And this presents an uncoercive environment for decision-making, which reinforces individual autonomy as the decision remains that of the individual. In other words, peer support reaffirms the individual as the decision maker. So that's the way we were able to establish in our research, and I think we will share a link in terms of how of course, peer support enables persons, specifically with psychosocial disabilities, to exercise their legal capacity. Thank you.
So I really appreciate that, and I have to say that, you know, when I've been asked about can this work for everybody, and we talk about psychosocial disabilities, I say nobody has a clue except the folks in Kenya. So I really tip my hat, and also to the fact that it is so nuanced, and that's really, I think, the issue, because it's all fine to write about this, it's all fine to talk about this, but when you actually try to do it on the ground, it looks very, very different. We have been fortunate in New York in that we had a 5-year grant to create a process for providing support to people with intellectual and developmental disabilities. And I was asked about high support. I think maybe moderate disabilities, maybe a little more than moderate, but no severe disabilities. And it's taken us 5 years to do that. And partly because at least the people we're working with do not see themselves as decision makers at all. I mean, they've never been asked to make decisions. Everything has been decided for them. Services have been provided. They think in terms of goals that someone else will move them towards, not that they need to make decisions. So it starts with just literally teaching people what a decision is and how you make it and what the steps are and where you might or might not want support and why you might or might not want a particular kind of support in a particular kind of decision and from a particular person who you have chosen as a supporter. And that's a complex process. And our experience is that it is not a quick process. It takes time. It takes hard work. We have a facilitation model, which is, you know, not dissimilar to the other pilot projects around the world, although obviously tailored to the budgetary and other, you know, issues, including the issues of diversity of language and race and class and et cetera that we have in New York State. But we find that our trained facilitators require at least 12 meetings in a 3-stage process, which begins working directly with the person who we call the decision maker to indicate their centrality to the process, and then subsequently with the supporters that have been chosen, and then ultimately with the supporters and the decision maker, literally to negotiate the contract, the supported decision-making agreement. And everyone in this process, I mean, this is the great learning. The decision makers, the supporters, the parents, whether they're supporters or not, and the facilitators say this is a transformative process. I mean, the person who walks in is not the person who walks out. The level of their ability to perceive themselves as agents of their own lives is really very substantially increased. And they are given the tools and the scaffolding to do that. It can't be done quickly. I mean, maybe it can, but we certainly haven't figured it out. And I think that we're trying to be as honest and as authentic as we can in saying, you know, we know how to do this for this population. We do not know how to do this for the population of people with dementia. This is not transferable to people with psychosocial disabilities for all the reasons that Michael said. It requires a whole different set of steps. So I think it's really incumbent on everybody who's doing this work, and again, so much of it has been generated by academics and by lawyers and by people, you know, speaking more abstractly in the area of rights, to really double down and figure out how you do it, because otherwise it can just be another fraud. You know, it can be a fraud like limited conservatorship or blah, 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 blah. To do it right is hard. It costs money. It takes time. We actually have a model. We've built out a model that we hope will go statewide. And we figure that it will cost about, I mean, remember this is the US, about $7,000 a person to do the facilitation process out of a budget of our Office of People with Developmental Disabilities, which is the Medicaid and other funding of $8 billion. And we are pressing to figure out ways that we can show how this is going to save money. And my partner said to me, who is not a human rights person at all, said to me, $7,000 to change someone's life? Why would you have to show cost savings for that? And the answer is because that's the world we live in. So I really want to bring home that we should be modest about our accomplishments, but ambitious about our goals, and then we have to keep pushing. But you have to do it empirically. You can't just do it on paper, because if you just do it on paper, we have what we have in 10 states in the US now, which is people can sign supported decision-making agreements without having the vaguest idea of what they're signing, with their supporters not having the vaguest idea of what it means to really give support. And then all of a sudden, you've got guardianship on the cheap, quite frankly, and all the possibilities for abuse that involves. So we should be more focused on the concrete and material base for doing this than just the kind of principles, although it always has to be guided by the principles.
Absolutely. Thank you for that, Chris. I want to go to Anna next, because I know that you might have to leave soon, Anna, and there's a question on gender that I think would be great if you can answer, to hear more about what are the specific ways in which gender influences the restriction of legal capacity. So, hi, Freya.
Hi, yeah, Freya's joining us for this part of the webinar today.
We support her.
She just woke up from her nap, so she's a little bit shy. But yeah, thank you so much for the question on gender. I believe that was from Anna Fierro, I think, Anna Rojo Fierro. Yeah, and I think it is a really important thing that we haven't talked about enough in general in the area of the right to legal capacity. I'll just briefly touch on some things that I think are important to just maybe to start thinking about. One thing that I wrote about in terms of a sort of theoretical issue is that there is a long history of sort of prejudice and stigma related to gender and rationality and decision making, and I think that there is a connection there between the prejudice related to women and gender minorities' decision making skills, and the use of legislation and informal practices to deny decision making. So I talk a bit in my book about the myth of hysteria in the context of women, the myth of illness in the context of gender minorities, and the myth of incapacity in the context of women with disabilities in particular. And of course, there's some intersecting identities there as well. So gender minorities with disabilities might be experiencing prejudice related to both the myth of illness and the myth of incapacity, for example. And then I think I think there's a potential that those sort of historical prejudices are causing things like higher rates of women under guardianship in certain jurisdictions, higher rates of women and gender minorities experiencing denials of the legal capacity to make reproductive choices and exercise sexual agency. And that's especially women with disabilities as well that are experiencing that. And then I think also something that we're overlooking is the specific experiences of women and gender minorities in the context of mental health and involuntary treatment and involuntary detention. There's a bit of research out there, but I think it's not enough. The rates of sexual abuse in that context is quite high. And I think there's definitely some gender issues happening there. I only laugh because issues is such a not strong enough word. And the last thing I wanted to mention, I'm sorry I'm throwing so many things in here, but just want to kind of flag them because I think a lot of them are important and there's so many more as well. The last thing is gender recognition laws. And I think that hasn't been given enough attention in the right to legal capacity context either. So gender recognition laws are laws that allow you to change your gender or have your gender legally recognized as whatever you want it recognized as. And of course, not all gender recognition laws do exactly what we want them to do. But the reason that they're really important is that if an individual isn't able to have their gender or non-gender legally recognized, they don't have access to legal documentation that would allow them to be recognized as a legal person and exercise legal agency. And I think this is a really big problem in the context of gender and the right to legal capacity. I hope that was a good answer to the question, and I really also would welcome any of the other panelists' comments on this. And of course, I'm open to other questions or comments in the area as well from participants. Thanks so much.
Thanks, Anna. Unless anyone has a very urgent thought on gender, I'm going to move on because we have so many more questions I want to get to. So the next question I want to put to the panelists is about law reforms. So we often see law reform proposals that are an improvement, but still rely on substitute decision making. So in advocating for change, how should we encourage legislators to fully embrace Article 12 without discouraging them from initiating promising reforms? I'm going to throw this to you, Alberto, initially, since you have the most promising practices to share in that respect. I have some thoughts on the Irish context, but I'll see how great I feel about sharing those. Thanks, Alberto.
Thanks. I think it's always a difficult question. Should we advocate for a complete paradigm shift or for incremental reform? No, and my impression is that the second approach is really not showing promising results. I think alternatives were available in countries like Canada, Italy, and things didn't change much. And I have been personally involved in the reform in Peru, and many times we felt like giving up and just introducing support decision-making measures while keeping guardianship, as it happened also in the region with for example, with Brazil, with Argentina. But I have the impression, and the work we did with the Special Rapporteur on the Rights of Persons with Disability, reviewing different processes, it was that in practice, implementations of those alternatives, when the other door was still available, it failed. And it failed because numbers don't show up at transition, because I think something that was said at the beginning by Kristin is very important, which is we just keep moving the line towards those that we feel are more disabled. And I think that's one of the issues, that you really need a paradigm shift to ensure a complete transformation. That is not about who can or cannot make decisions. It's not about decision-making abilities. It's really about how we ensure all human rights for all people. And I think that's when I feel, if we want to go for a law reform, I think we should aim for the highest standard. I see an opening. I think I'm not an expert on the legislation in Spain, but I think just that reform happening is going to open new opportunities for I think other countries to take on, because the influence that can have Spain, especially in civil law countries. I know there is also questions about I just wanted to jump in something else because I felt it was important. Is I think it's important also what has been said, that law reform is important, and of course having the law, as I said, on your side is already a great starting point. But services are needed, and whereas formal services or peer support groups, as Michael was explaining, but you need support available. And I think, again, Kristin mentioned that we need to work on the ground. And we in Peru, we did a pilot project before the reform, and we're conducting a new one now to improve let's say the practice. But for me, the biggest question is how we scale such projects, because we need the buy-in of the states. And there has been a lot of effort from civil society, but we need the buy-in of the states. And I think, again, law reform can open that space. But also there is a need for paradigm shift in society too, no? Because those empowered may be able to use the law, as Gerald liked to say before, as a sword or as a shield. But many people with disabilities, particularly in low and middle income countries, rely significantly on their families. And we know substitute decision making operates in those frameworks, that guardianship is actually a de facto situation for many people where people make decisions for you all the time. And if I want to bring this back to the law, I would say a learning from the Peruvian process was, I think we made a mistake not having a clear framework for the implementation in terms of clear obligations in the authorities leading to the development of services, clear training of supporters at the ground, and clear obligations in terms of awareness raising. I think those aspects are critical, and we're seeing that now in the implementation of the reform of Peru. And just to finish with the question on people in coma, I think that's always the first question that comes in any debate, and probably for me it should be the easiest one, because why deny somebody that in practice cannot manifest their will, their legal capacity? And wouldn't it be better to appoint a supporter and apply the best interpretation standards, so when the person awakes, still has their rights in place? And we try to do that. And again, these things came up in a couple of reforms in Latin America. In Argentina, there is a standard around people in coma that actually prevented further reform. And in Peru, actually, we have an exception again for people in coma who could actually be restricted of the legal capacity, which makes little sense, as I mentioned. But it's true that even in those cases in Peru, they will operate under the support framework, and it has to follow the best interpretation of will and preference. But I think that was one of the mistakes of the reform.
Thanks, Alberto. And if I could just add to that a little from the Irish experience, I would say that now for sure we have the examples of Costa Rica, Colombia and Peru, which we can give to the legislators who are nervous about whether this can be done, because we did not have those examples in the Irish context when we were pushing for the Capacity Act 2015, and legislators and officials asked us all the time, like, show us somewhere else who has done what you're saying, and then perhaps we'll take you more seriously. But we also received pushback, you know, from within the advocacy movement or kind of other stakeholders. Sometimes I remember one person asked me why we wouldn't just push for something like partial guardianship, because we currently have full or plenary guardianship with the wardship system, and why not just try for partial guardianship first and then show that the sky didn't fall in, and now we can push for supported decision making. And that person made an analogy with marriage equality, and look, there were civil partnerships came first, and then the sky didn't fall in, and then there was marriage equality. But I argued back that we were dealing with a law from 1871, so how much longer, if we went for partial guardianship, would we be working to try to dismantle that? But it certainly was a really difficult thing to convince lawmakers that we could make that complete shift in one go, and it is a challenge. So I completely understand anyone who's facing that dilemma right now, and only can wish you luck and say that there is a network of people who have this experience, Alberto and other colleagues, and we can be in more contact with anyone who's trying to push for similar reforms, and we want to continue that conversation. Does anyone else want to comment on the coma question about how we manage cases when someone is in a coma? I think Alberto answered that perfectly, so I don't have anything to add on that point.
Eleanor, I'd just like to talk about the legal issue for a second.
Yes,
Because while I agree that we're going to get nothing but reforms, it's going to be nothing about pushing more towards people who are more disabled. I think that there's another legal area, at least for people with intellectual and developmental disabilities, which again, our experience over the past 5 years has really demonstrated to me is the way to make a change for that population, and that is changing education laws to require, as part of all education for all kids, but maybe with some particular additional supports for children with intellectual and developmental disabilities, teaching them decision making and teaching them how to use supports, and doing that from pre-K. I mean, I understand I'm talking from a developed country that has universal pre-K, but really from the very beginning, teaching kids how to make decisions, teaching kids what the aspects of those are, teaching kids where they're looking for support and where they're looking for help, so that by the time they're 18, which is at the moment at which people get pushed into guardianship in our system, because their parents now no longer have legal authority over them, the problem will be solved. I mean, they will have a system in place, and I think for that population, we can really get rid of guardianship within the next 10 to 15 years if we embed it in the legal system, and that, I mean, in the educational system, and that's a different legal strategy, but I think it's a strategy with enormous potential, because as we do it, people see it works, and parents are hungry for this. They really are. I mean, we are in a generation that sees a possibility, again, in the developed world, I understand this, but sees the possibility for a different life for their children with disabilities than 40 years ago. You know, the special child, the angel who will always be a child, and all of that. So it's there, it can be drawn on, and the more you show it in practice, again, show it in practice, do it, prove it, show it, the more incentive there is. And it's part of, it doesn't even cost more, right? Because you're educating kids anyway, so educate them to do this instead of educating them to be complacent, which is what we do now, and to take orders.
Amazing. I think that would be a great revolution for the education system as a whole, not just for this particular community. Okay, so I want to move on to our next question from Jen, which is about any suggestions for how to direct activism in this moment of heightened awareness. So for people who want to directly support advocates and activists with funding or allyship, what's the best way to do so? So I'm going to see which of the panelists might want to address that. If any, again, I guess in the US context, Chris, you might have some suggestions, and then more globally, Alberto, perhaps you have some suggestions as well as to who you can support in this kind of work.
Well, I would just say, I mean, we're so far behind everyone else, again, because we don't have any human rights context at all. But the really powerful connector, I think, for us, and interestingly, for the decision makers that we work with, is that this is an international movement. And certainly everything that we have done in the US, and certainly in my project, has been informed by the work of others. And I mentioned that folks from Colombia and Peru actually came and met with some of our decision makers and our supporters in New York. And, you know, we've learned from them. This is just an incredible community. And our decision makers are so excited when they think about themselves as being part of an international movement. So don't ignore that in whatever allies you have in your own country. And again, the best allies, I think, are people who have actually done this and who have turned the corner and who show that it is possible, that with the belief that anything is possible and with the support necessary, people can do anything. They really can.
Do you want to give any particular shout outs, Chris, to some of the projects and initiatives on supported decision making, including Supported Decision Making New York, that people could actually support with funds or through other means by promoting their work?
Well, I don't want to say we don't need money, but I mean the amount of money we need, you're not going to be able to give to us. But I would really encourage you to look at our website. We have a lot of fabulous videos. And one of the things that we've learned during the pandemic, you know, by necessity, is that what you can do with videos, even videos that are done over Zoom, are really powerful. And just a quick story, we were looking for some foundation support, and I thought we were going to get it, and the director really wanted to give us the money, and then I got a call saying, you know, our board doesn't believe that this works for people on the spectrum. And I was like, but it does, you know, we're working with them. And we put together over the weekend a video, which we'll actually put up and you can look at, of parents, of decision makers, and of experts, you know, somebody from ASAN and whatever, you know, talking about it. And that was so powerful, and the board changed its mind. So the use of videos and testimonies is just incredibly important. You are welcome to anything we have. You know, we are open source. Please feel free to use it. But it's just sdmny.org, and please feel free.
Thank you, Chris. Alberto?
Yeah, I wanted to jump on that because I feel this greater awareness that we have now because of the case of Britney. I think there are many things that are important as part of the process of implementing the right to legal capacity that sometimes we take for granted. No, one is what Kristin was saying, supported decision making in practice. How does it look like? How we can implement that? And I think donors have played an important role on this. Recently did a paper with a couple of colleagues reviewing 3 experiences of support decision making in Latin America, all of them funded actually by Open Society Foundations. And I think that shows how, and in 2 of these countries, we had actually after that reforms. So I think it's important to highlight that, no, the role that donors can have in mobilizing some agendas, and especially to create the knowledge, creating knowledge that is the most difficult part. But the other part I think is quite important is opening the circle. I think we have kept the circle too small sometimes. I think for a long time, this was a discussion of people with psychosocial and intellectual disabilities, not even people with autism, not even people with multiple impairments. And I think building the case that this is an issue that not only for the disability community, but that affect us all as a society is very important. Because it may affect us later as an older person, it may affect us in so much different ways. And I think opening those circles and building those alliances is key. When we started the process in Peru, we were really just a few organizations, and then really building the connection with the disability community, with the human rights community helped a lot. And sometimes it's things as simple as blind people realizing how actually legal capacity is restricted in day-to-day life when they go to the banks, when they do some legal transaction, when they have some restrictions, when they do procedures at notaries. So just creating that awareness and that exchange and taking on board those different perspectives help us to create something bigger, I think. And I think that's always important to keep in mind, how to open the circle.
Could
Anna?
I mention one?
Yeah, please.
Yeah. One other thing that came to my mind that I think is important is a little bit more about the individual. And I think one thing that's really important, which I think is an important form of activism as well, is doing what you can as an individual. And so in the context of my family, what we're doing is doing everything we can to not use those restrictive laws, and it's hard. And I think there's a lot of families out there and lots of individuals out there that are in that situation, that really don't want to use these laws that are violating people's human rights. And I think that really is a form of activism itself, is doing everything you can to avoid them. The other thing is having conversations, even if they're just with one other person. I think Chris and I have talked about this a lot, but when I was a law student and I was, I think I was like 23 years old, and I had met a few people that were drafting the CRPD in New York at the time and was really excited about the right to legal capacity. And I thought, I'm going to send an email to Justice Kristin Booth-Glen and have a chat with her. And here we are, how many years later, like 15 years later or so. And I think those personal conversations, and I, of course, really only intended to have a personal conversation, really. And so I think those conversations can be really important, both with other individuals that are faced with this type of restrictive legislation, and with people that are sort of just thinking about it and thinking about different things in this area. So yeah, I think that individual kind of activism can be really powerful as well.
I absolutely agree, and I think that's a great message to leave everyone with. I have convinced my local coffee shop all about this issue because that is my main human contact outside of my immediate family these days. So okay, so we're approaching the end of our session, and I've also posted some suggestions in the chat as we've been going through the materials that have been discussed, and also the some suggestions I have for more the Irish context of people and organizations led and directed by disabled people who deserve more attention and who are working hard on issues like this. But Michael, I want to return to you and to all our panelists to see if there are any final messages that you would like to leave the group with today, or anything that you came here to say that you haven't yet had the opportunity to put on the table. So we can start with you, Michael.
I mean, just to reinforce in terms of how we can, support work around, reform around legal capacity. I think for me, the core of it is sort of trying to understand, to make people with different types of disabilities to understand what Article 12 means in a very simple and accessible way. I think that for me is very important. And I think the issue of coalition building is very, very important, because we are talking about very complex issues that you're bringing, for example, to legislators. So I think I found it useful working with national human rights institutions. That's for me is very, very critical. The training of legislatures and people who are involved in the law reform process, it's also quite critical for me. And I think my last point, of course, is like in Kenya, we've been using litigation to challenge certain provisions, for example, in the Mental Health Act, which we strongly feel they are not in compliance with the CRPD. I think that my last point of observation is in relation to maybe probably donor partners and community. That sometimes there's obvious tensions within country and even in the African level, because on one hand, they are funding projects which are CRPD compliant. On the other hand, they are funding, for example, projects which are, of course, implementing mental health, development of mental health laws. And it creates quite a lot of tension in terms of then how do we move into CRPD compliance if, for example, the funding streams, one is advocating for full legal capacity, the other one is talking about mental health laws, which still have provisions of guardianship and all that. So I think those were important points to observe in terms of how we move forward in the whole process of legal reform.
Thanks, Michael. Chris, I'll come to you next. Any final thoughts that you want to leave on the table?
Do the work. Always center it on the decision maker. Let the decision makers take the lead. Nothing about us without us. That's been so important to us in our own practice. We learn every day from our decision makers. Take strength from the wonderful work that's being done everywhere, from Peru, Colombia, and Kenya, and Bulgaria, and the Czech Republic, and Ireland. And I think, particularly in the Britney Spears context, that it is the human rights lens that has to be focused on here. It is the equality of all people as human beings, as agents in their own lives. It's not just about taking away this disabling law and legal situation from someone who doesn't deserve it. It's about a recognition of the rights of all people. And so if ever the human rights perspective was important, it's now.
Thank you. Alberto?
I don't know. I think my final idea will be that I think we need to keep thinking and strategizing how to move and push the agenda, and this is something that I think we keep saying, but how we bring everybody together so we can make the best use of the resources available, and we have people that have gone through this. We have people that are very good advocating. We have people that is very good communicating. We have people that is very good at lobbying. How we bring all these people together so we can ensure change. I think that's the key aspect of this, no? And let's take advantage of this awareness to push for some more change.
Great, thank you. Anna?
Thanks. I think just following on what everyone else is saying as well is that I think we really have to pay attention, because equality before the law and the ability to exercise your legal agency is essential to power and privilege. And ultimately, even though we talk a lot about power and privilege like it's a bad thing, ultimately that's what we need is equal access to power and privilege for everyone. And I really think that legal capacity and equal recognition before the law and legal agency is the key to power and privilege and to having a more equal distribution of power and privilege. So I think it's keeping those things in mind and making sure to think about it in different areas of the law that you're working and in practice and also in our personal lives and personal interactions. Thanks so much. Thanks so much for organizing this, Eleanor, as well.
Of course, it's been my pleasure. I've been so lucky to have to be able to quickly call upon all the people in this seminar, and particularly to our background team at the Centre who pulled this together with very short notice, and also to our amazing interpreters and captioners who have made the event so accessible today. So just a reminder that we will be posting the recording of this online for people to view afterwards, because I know several people have mentioned there's a lot of new information to absorb. And so we are very grateful to our panelists for agreeing for this to be posted afterwards. And just a final message from me as well. I want to say to people who have been awakened to the injustice of guardianship because of Britney Spears, welcome. We've been waiting for you. We're here. We are ready to work on this together. We should build a broad coalition. So to anyone who is newly becoming an activist around this issue, excellent, join the club. And also on a final note as well about the power of educating the next generation, including the next generation of lawyers, because we do need their support if we're to dismantle this system. And that's something that we're very invested in Galway, and I know all of you are invested in as well in the different education programs that you are part of. But a final plug for those who are interested in exploring this further, do consider thinking about the master's program we offer in Galway on disability rights. And if you have any interest in it at all, please get in contact. Okay, that's it for today. Thank you so much to all of our amazing panelists and to our backroom team and captioners and interpreters. It's been a privilege to spend this time with you all and our fantastic audience for asking such insightful questions. So keep in touch. We will continue the conversation, and you never know, we might have another webinar or two on this, following on from what we've learned on this issue in the future. Thank you all so much.
Thank you, Eleanor.
This webinar has been organised by the Centre for Disability Law and Policy, a research centre based in the Institute for Life Course and Society at the National University of Ireland, Galway. Our research centre is engaged in research, education and community outreach work in collaboration with the disability community, in keeping with the philosophy of nothing about us without us. We host regular events about disability rights, including an annual international summer school, and we also provide research projects, community outreach work and various education programs, including a vibrant master's and PhD program, which we would encourage attendees at this webinar to check out if they're interested in further research on this area. So our master's program is called the LLM in International and Comparative Disability Law and Policy. It is running online for the academic year 2021 to 2022. And applications remain open for those students who would like to start the programme in September 2021. The programme runs from September to August each year. Students can choose between options for full-time and part-time study. The programme takes 1 year full-time or 2 years part-time. Modules which students can choose from include Foundational Theories of Disability, Legal Capacity Law and Policy, Mental Health Law and Policy, Advocacy and Access to Justice, Inclusive Education, Independent Living, and many more. Students will also have the opportunity to conduct a research dissertation or minor thesis as part of their work for the master's programme. And students also have opportunities for prestigious internships based with the UN Committee on the Rights of Persons with Disabilities in Geneva. For more information on our projects and programmes, Please check out our Facebook page, Centre for Disability Law and Policy, our Twitter account at NUIGCDLP, or our website nuigalway.ie/centre-disability-law-policy. Thank you for attending our webinar or listening back to this recorded version, and we hope that you will keep in contact with us and our work.